Hello, I'm attorney Lewis Haskell, and yesterday President Biden announced a new parole in place program for people who've been in the United States for over 10 years and are married to United States citizens. There's been a fair amount of hoopla over this. Some people believe that yesterday was a historic day, others that this is the end of the world. Both are wrong. Before I begin, I do want to make clear, though, that as we sit here today, nothing has changed. The President has announced that there will be a new program, that they expect to roll out that new program in late summer. Keep in mind, summer ends in late September, not when the kids go back to school. And as such, there is a process that we're going to have to go through, even in terms of finding out what the program is, what it entails, and more importantly, what we have to do to become part of it. But let me tell you what we know. We do know that the President made an announcement. We do know that the Department of Homeland Security has put out a fact sheet. We do know that USCIS has made an announcement on their website. And what they have said is that this program is for people who entered the country without authorization. The legal term of art is entered without inspection. The colloquialism is walked over the border. So this program does not affect people who entered the country legally. And that includes people who, for example, entered on tourist visas and simply stayed, because all those people are already eligible for adjustment of status and don't need this help. This is for the people who cannot adjust status because they, as I say, entered without inspection, came in without telling anybody, basically, without permission. But this is important because for the last, 15, 18 years, these folks have had a problem because they can't get a green card in the country. If they leave the country, they're subject to the 10-year bar before they can come back. And so although we have had for the last 8 or 10 years a program of advanced parole or advanced waiver, where people could apply for a waiver to the 10-year bar, get the waiver, then go to their home country to get their visa and come back. A lot of people have, for whatever reason, either chosen not to bother with that because it is a very cumbersome process, or were turned down for their waivers and couldn't leave and come back. It's estimated that this program will affect 500,000 people who are married to United States citizens and yet ineligible for adjustment of status. I will say that that number seems high to me, but the number is what it is. And this is part of why I say it is neither a historic day. I mean, we're only talking about 500,000 people. It's not the apocalypse. We're only talking about 500,000 people. But for this 500,000 people, here are the rules. Rule number 1, you must have been in the United States continuously for 10 years prior to June 17, 2024, meaning you must have entered the country on or before June 17, 2014. You must have stayed here continuously. There are people in unlawful presence who do go back and forth. Those people have more or less disqualified themselves. And you must have been actually here on June 17, 2024. The next requirement is that you be married to a United States citizen on June 17, 2024. I will be curious to see what happens to people who are married to a lawful permanent resident on June 17, 2024, and then the LPR naturalized after June 17, 2024. But the way it's been announced, without more, I would say that those people are out of luck. I will be surprised and disappointed if it ends that way. But in terms of what they've announced, it is you must have been married to a United States citizen on June 17, 2024. So that's the basics. They say you must be otherwise eligible for adjustment of status. That to me is an interesting one. It would surprise me if a public interest parole application required proof of the bona fides of the marriage, for example. But that certainly would tend to indicate that it might. So again, we just have to wait until the actual rules come out before we know. I've been reading various articles, watching various, videos and whatnot. Some people say it's required, others say it's absolutely not required. The correct answer is we do not know. Okay, as I say, nothing's been published in the Federal Register. This program has no rules. There are no forms available to fill out. We only know that something is going to happen, and I'm just reporting on what that something is. There are requirements that the person not be a threat to public safety or to national security. This one I'm going to go back to the otherwise subject for adjustment of status because it does create another set of interesting issues. A lot of crimes that people can commit would, at least on the surface, make you ineligible for adjustment of status, would make you ineligible for admission to the United States. Some are absolute bars, the aggravated felonies, and I think it's easy to say that a person who's been convicted of an aggravated felony is probably not eligible for public interest parole. However, a lot of crimes are waivable, and that's part of the adjustment of status process, and I do not know how that's going to play out in the public interest parole context. But this is something we will be keeping an eye on. How they're going to handle something like distribution of a controlled substance when that distribution is not an exclusion ground because, I don't want to get into the weeds here, but for example, the Massachusetts cocaine statute is overbroad and doesn't match the federal statute and therefore can't be used, but it does seem that it could be used on a discretionary public safety grounds. And then another couple things that they keep saying is that this will be adjudicated case by case and that this relief is discretionary. So here again, we have words that have meaning, but we have not yet been told what the meaning is. Just know that I'll be keeping an eye on that. And when the rules are announced, I'll probably be making another video, but more importantly, when I have clients who want to take advantage of this, I'll be able to counsel them properly and navigate them correctly through this process. So as I say, we will know a lot more probably in September. We will have forms available probably in September. We know that there will be a filing fee. We do not yet know how much that filing fee will be. We do not know what the document requirements will be, but some are pretty obvious, beginning with trying to document that you've been here for the last 10 years. One of the problems with, and I'm going to use the A word, amnesties. Now, I'm old enough to remember the original amnesty, and I appreciate that that's a politically charged term, but I don't think it's a politically charged term, and I don't think it's a bad word. I happen to like amnesties. One of the problems, though, with amnesties is for people who are trying to be off the grid, trying to be underground, trying not to be found, to now turn around and document that they've been here for a long time. And so in terms of practical problems, that is something that people are going to need to focus on. And in terms of what people who want to take advantage of this program can be doing between now and September, when they can actually do something, that's where I would start, is trying to dig up, documentation of old addresses, old jobs, pulling out your old picture books, whatever, to try to find ways of showing that you've been here for more than 10 years. Because this is a practical matter. I see that as the big problem coming down the pike. In terms of when this will actually happen, though, it's hard to say. It will not surprise me if somebody files a lawsuit trying to stop this thing this week. That, of course, is silly. I don't know how you seek an injunction against a presidential announcement. You kind of need to wait and see what they're really doing. And you kind of need to wait until there's really a program before you try to stop it. But I'm sure it'll be in court this week because that's what people do. And I'm sure that there will be more serious challenges to it in September. And here is where I think it gets interesting. This is a public interest parole program. And what makes public interest parole fascinating in this context is it grants a legal status, which means it now makes it possible for the people who get the parole to apply for their green card without leaving the United States. I think I want to make another video talking about how the court will address this in light of the recent bump stock decision in which the Supreme Court has declared that it is purely textualist, because in a purely textualist context, I think this survives court scrutiny. for people who are hung up on legislative intent, I think there's a problem. So as I say, we're going to be watching justices twist and contort as they try to uphold or strike down this thing. But that's for another day or another video. In the meantime, it is, an exciting development for the people who've been here for the last 10 years who are not eligible for adjustment of status, notwithstanding that they're married to a United States citizen. I know that I do have a couple of clients who I've had to tell, that there's nothing I can do for them now, but I'll be watching and we'll let them know if there's something I can do. Well, turns out there's something I can do. I look forward to working with more people to help them obtain their parole in place, and thus their work permits and their freedom from fear of deportation, and ultimately to helping them to obtain their green cards. Thank you.